Good afternoon. I'm Diann Cohen with MacroPro, and I'm joined by Mandy Farquhar, my colleague. Mandy, how are you?
Great. How are you, Diann?
I am great. This is our very last 12 CEUs of Christmas. This is actually a baker's dozen. James and I are doing the 13th, so we always want to make sure that we provide more than what we promise, right? That's one of the things we're doing. So thank you for co-hosting with me today.
Thank you. Thank you for having me.
So earlier today, we did something that was kind of fun. We asked a question. So for those of you that weren't with us in this morning's presentation, I'd like you to get over to the question box because I'd like you to answer a question. We've got a Christmas trivia question. So Manny, I'm going to ask you this question. Let's see if we can get it right. All right. So Rudolph the Red-Nosed Reindeer was created first as, and you get three choices: A short story for a newspaper in the early 1900s, a cartoon in the 1960s, or as an ad campaign. So which of those three things was it? A, B, or C? Oh, look, we got people chiming in already, Mandy.
I think it's B.
You think it's B? You think
Yes.
it was a cartoon in the 1960s?
Yes.
Okay, I'm going to give some people a little bit extra time. Go ahead, people in our audience, A, B, or C. And we'll see. So we got some C's, we got A's, we got B's. We have one person that says, I don't know. And that makes sense because, we don't know everything. So I'm with that person. We got lots of B's. Well, the answer, only one person actually got it right that I can see. And Keisha. And the answer is ad campaign. So this is a bonus question. It was an ad campaign. So can you tell me which company created? Was it Sears and Roebuck, Montgomery Ward's, or Dillard's department store, as it was a competitor of Macy's and perhaps it wanted to rival the Macy's parade or something?
I say Dillard's.
You say Dillard's? Let's see what people say here. Dillard's. Hi, Debbie. Hi, Riza. Oh, nice to see so many of you guys here, a lot of our friends. All right, so we see that. Well, the answer is Montgomery Ward.
Oh.
And the creator of it, this is kind of cute. The creator of it wanted to do something on the lines of the Ugly Duckling because they wanted to show that everybody has value. And even though somebody with something different, like a red nose on a reindeer, they could contribute to the world. And so that's why he chose to a reindeer with a nose. So that was kind of fun. All right, let me get to our housekeeping and then we'll bring James on. So today's webinar is worth one CEU. You should receive it within 1 hour after our presentations, depending on your firewalls at work. You need to be logged on to the GoToWebinar platform. If you have any questions, Mandy is going to read all those questions for us today. So go ahead and put your questions in the box and we'll get those down. You can download the handouts. James' office did a really great job with the handouts. So you want to download those now so that you have them. And there is some other information also that you can download from MacroPro. And this will be on the MacroPro YouTube channel. So if you forgot something, you wanted to get a little bit more information, you could go back and see that. So I think we got everything. So let's bring James up. Hey, James.
Hey.
So very happy holiday to you. Let's tell everybody what you're going to be doing soon because we're all going to be wishing that we are James Rossi.
Well, it's funny. I'm going to Costa Rica, but I should be really excited, and I'm not that excited. I probably in the minority when it comes to that, but it's just it's weird being away during the Christmas holidays. So, but I'm sure I'm going to have a blast, and I have a tendency to do this with traveling. And once I get there, after doing a little bit of whining, everyone says, "See, you enjoyed it." So I'm that guy.
Oh, you are? Oh, yeah.
I am. I'm that guy.
Yeah, my family's polar opposite of you. So.
Most are.
Well, it is a fantastic trip you're going to have. Okay, James, let's get started. Let's talk about unlocking successful apportionment.
All right. Well, thanks for having me, and I'm happy to do this with you. So we're going to start off by talking a little bit about permanent disability. Basically, the evolution of a claim. It starts out with an injured worker who has an injury. He starts receiving treatment. He's placed on permanent temporary disability because he can't work, or maybe he's working with restrictions. And at some point, after all the treatment's done, it gets to a point where they are found maximum medical improvement, which means treatment is completed as far as we're going to get. This injured worker is not going to get any better with the treatment. And so now they are stable enough for us to issue a permanent disability rating. And so once we get to that point, a doctor will look at all of the ratings, all the body parts, etc., figure out whole person impairment, and then we turn all those whole person's impairments into a combined rating, and there's an overall PD rating, and then we convert that to the monetary value. And so we're going to be talking about apportionment and how we can bring the monetary value and the percentages down. In part, we're going to talk about a lot of things, but that's the main thing. So this book here is the AMA guides. It's the evaluation, how we evaluate permanent disability and workers' comp in California. And it's pretty much the Bible when it comes to permanent disability. A doctor is going to be required to go into this book and determine what chapters, sections, etc. apply so that they can properly rate any permanent disability, any body part is going to be found in this thing. It's quite vast. The chapters that we deal with the most would be chapter 15, which is the spine, chapter 16, which is the upper extremities, and chapter 17, which is the lower extremities. That's the majority of it. But this thing has everything. It's got reproduction, respiratory, cardiovascular, skin, digestive, vision. It has pretty much everything you can think of, and it's very comprehensive. And the vast majority of this book, it is inapplicable to the vast majority of cases, because most of these chapters you don't get into unless there's a more serious or unusual injury. But most of our injuries will fall into the 3 chapters that I mentioned below. And they're required to look at it. We're going to talk about some of the exceptions. And here, once we do have ratings, whole person impairment, then we've got to calculate it and make various adjustments. And Diann, why don't you talk about the Macro Pro calculators?
Yeah, so this is a really amazing tool that we provide to our clients. As long as you have a username and password, you can utilize it. And it is a PD rater. And this PD rater is just like basically fill in the blanks. If I always say, if you graduated the 3rd grade, you can do this because you're just putting in like the age of the person when they had their accident, the day of the accident. And then what's really cool, you can see here where it says enter occupation. So when you do the enter occupation, you look what it is, and then we actually give you a rating on it. So you can see whether or not this is the right thing you should be rating on, because you don't want to get a bad string of numbers because you got the wrong job. Sometimes it's clerical 1, clerical 2, clerical 3. So each of those groups have their own ID number. So you're going to click onto that. You're going to be able to read it to make sure that you have the right information. And then you have your body parts. And what's really great about ours is once you pick spine, like James says that they do that, then when you look at the impairment, you're only going to look at the spine impairments. There's nothing else in there other than that. So you're not having to weed through a lot of stuff, James. You're just looking for what is related to the spine. Then you're going to take the doctor's whole person, and then the amount that was associated and apportioned to the workers' comp claim. You're going to do the formula, you're going to put in the weekly wages, and then you're going to get that entire thing there. And you'll see in his slide that there's a string there. And so you could cut and paste that string, put it into your notes, and you have it. You could take a screenshot and do the same thing. But what's really cool about ours is you can do multiple body parts, and they'll do that. But what I really like is ours is smart, because if there's supposed to be a plus or minus 15%, it's going to put it on there automatically for you. So this is a really cool tool. So James, now everybody knows how to use it. Now tell us what it is that you use it for and how it comes across.
Well, I think these calculators are absolutely fantastic. But before I get into it, who has the ability to use these on your end?
On our end, anybody that has got a username and password.
Okay, so if you're not already using these, people, I highly recommend it. It's so much easier. I hopefully not many of you are calculating ratings by hand, but it's a much quicker process to use these calculators.
Yeah, you can do it in 30
because
seconds.
you can do it in 30 seconds. And the thing is if you get a case where you've got, 8 different body parts that all need to be rated, and you got to use the book, which this is the rating schedule right here. This is what it looks like. Done by, I don't know if you could see it, but it's got all kinds of information, occupational job number. These are all the occupations. It's got all kinds of stuff in here. You got to go through each section and adjust it. So when you get a whole person impairment from a doctor, you then have to apply an FEC, future earning capacity adjustment, and then you got to adjust for age and occupation. And in the book, typically what you would have to do is figure out, the exact occupation, what's the code, and it's just math. It's a lot of math. And if you have to do it on 8 or 9 different body parts, it can take, 3 to 5 minutes per, whereas these calculators you can do the whole dang thing in about 3 to 5 minutes. It's quite amazing, because all you got to do is plug in the impairment that the doctor gave. So in this particular example, it was a DRE of the cervical spine. The doctor said 15% whole person, said it was 100% industrial. And then we've got the occupational group number, which was a 380, the date of injury, and then the date of birth. And then boom, there it is. It spits out the actual rating. And then you're golden, and you just take all of those ratings, get them all down, and then you can do use the combined value chart to determine what the final rating is going to be. So with respect to the anatomy of a string rating, you see that 100% right here. I don't know if you can see my mouse, the mouse moving, but the 100% is how much of it is work related. So if you've got, say it's 75% work related and 25% non-industrial, then you would put 100%. That would be 75 instead. And then the next section, 15.01.01.00, that's how the doctor came up with the disability. So that would, in this particular case, be a DRE. Then the 15 is how much we start with in terms of whole person impairment. So the doctor said that this person had a 15% whole person impairment. So we plug that in. It's at this point, it has not been adjusted yet. So the 1.4, that's our first adjustment. That's a future earning capacity modifier. Now, due to changes in the law, all body parts have a 1.4 modifier. Before they did this, before they made it uniform, we had to look up in this book that I just showed you, we had to look up the FEC modifier for each type of body part. And so it made the ratings more complex. But the thing is most of them were not 1.4, they were less. So once they said we're going to make it 1.4 across the board, they actually increased the permanent disability on a lot of body parts. Psych, for example, was already a 1.4, but the vast majority were not. So it was an increase in PD for the applicants when they did that, other than, for example, psych. So that 15 automatically turned into a 21. Every time you got a rating, you're going to do that 1.4 automatically. Then you get to the occupation, and the occupational group number in this particular example was a 380, and so that turned a 21 into a 26 because it's the type of work that's hard on the injured body part. So you get a nice bump there. And then the next one is, once you've got that 26, we've got to adjust it for age. And in this particular case, we had a 46-year-old, so the age caused it to go up 2%, and your final rating's 28%. Since there's no apportionment, it doesn't get cut down. Now, if you had, say, 50% apportionment, you'd have a 50% in place of that 100, and the 28% would then end up being 14%. So you would have a tremendous amount of savings because of that. So when we have the combined values chart, we get all these ratings, and we rate them all out, And so say we've got two 10s, for example, a 10 on the low back and a 10 on the cervical spine. We'll take the combined values chart, and you'll see the numbers on the left. At the bottom of, if I showed you the whole chart, at the bottom it would have corresponding numbers starting at 1 and going on. So if you look, if you go start at 10 and you go over to where it says 19, that would be the equivalent of two 10s combined. And so it goes down when you use the combined values chart. It's always going to go down. Now, next thing I'm going to show you is something that is, it demonstrates the value of 100% versus a 99. Sometimes our goal is nothing more than to be able to show there's a 99% rating instead of 100. And it would seem like that's not going to be hard to do and get a 99 to 100. You would think it'd be really easy because they're so close, but it's actually not easy. And if you look at the dollar amounts that are available for a 99 versus 100 in this particular example, you can see why it should be so much harder to get 100% than a 99. So if we have a 40-year-old gentleman, high wage earner, and we adjust for present value in COLA, PD at 99% would be approximately $637,000. If they can find a way through a vocational expert or rebutting the guides in some fashion, which we'll talk about later, and they could turn that into 100%, suddenly that same exact person has an award of $2.797 million. So this is an extreme. You know, sometimes you have a smaller wage earner, and it will impact those numbers. But I just use the extreme so that you realize the difference, because there's typically, in almost every case, there's a huge difference. Maybe not this big, but huge. All right, so now I'm going to ask you to look at an example here. So we've started with a 99, and looking at this rating, you'll see that 71. So there was a 71 to start. Once we added the 1.4 modifier, it turned into a 99. It stayed a 99 all the way to the end. So we're starting with a 99% permanent disability already. Now, keep in mind that if it was a 72%, the 1.4 would have put it at 100%. So anytime you have a single body part or system that rates to 72%, once we put it into that equation, we're going to be at 100%. But this one, it's a 71, so we're only at 99. So now what we're going to do is we're going to add a 28%. So we'll use our combined values chart, do a 99 plus a 28, and you would think we might be at 100. And the question to you is, are we? And the answer is no. But now, what if we add a 36% permanent disability to that 28 and that 99? And the answer is still no. All right, but what if we add a 49%? So a new body part, 49% all by itself, added to all the other three. Believe it or not, we still have a 99. And even if we added this additional 49, we still have a 99, which is kind of crazy to me. The first time I figured this out, as I was trying to figure out a case on how to get a 99 up to 100, I was pretty blown away by this. So the way we get to that last percent, the 99 to 100, is by combining a single rating, single disability that equals at least 50% by itself, which is, not a lot of body parts going to have 50% by themselves. Most of the time, you see a surgical back, it's not going to be 50%, or a cervical neck by itself. It's the way they get into those higher ratings is because they add other body parts and specialties into it. So on the CVC table, once you can see that 50, adding to the 99 a 50, that's when you get your 100. So anytime you can keep these body parts under 50%, you're helping protect yourself, at least from a strict rating perspective, you're helping protecting yourself from getting 100% permanent disability award, which, as I showed you earlier, is very costly, big difference. So rebutting the PD schedule, this is something that whoever's trying to rebut it has the burden, and it's 99.9% of the time it's going to be the applicant attorney trying to rebut the schedule, and they're going to do it in one of three ways. The first one is Alvarez Guzman. The second one is Kite Vigil, where Alvarez Guzman, we're going to cover it, but it's probably the one you guys have seen the most. Kite is kind of is a little bit newer, and Vigil just came out this year. And then lastly is Ogilvy, which is, there's not a whole lot of Ogilvy left, but we'll cover it. So Alvarez Guzman. When it first came out, essentially what these doctors were doing is they were saying, well, the disability is not properly evaluated using the guides, and so I need to rate it. And they would come up with some theory as to how the rating should be because of their expertise, and they would try and explain it away, and they would leave the guides. They wouldn't. That book that I showed you earlier, they would leave that book. And so ultimately the court came down and said, hey, you can't leave this book. You need to stay within the four corners of the guides. And so then what happened was physicians would get creative with how they can use the four corners of the guide. So for example, they would have, say they had a hernia, which is typically not unrateable. They would say, well, he has the same simple symptoms and same issues as someone who had a lumbar spine injury. And so therefore, even though it's a hernia, I'm going to rationalize it properly and give substantial medical evidence that it should be rated similarly to a back injury. And so they would use that, and that's if it's done correctly, it's proper. Another thing they would do is, for example, say someone's got an upper extremity injury, and this is something they still do. They got an upper extremity injury. 60% is what the upper extremity is worth if it was completely, unusable. And so they'll say, well, this person, the strict rating is insufficient because he's got such a impact on his activities of daily living, and so therefore, I'm going to say he should be rated at using the 60% max for an upper extremity and dividing it by 80%, because he's lost 80% of his ability to use that arm. And so the rating would be 80% of the 60 and then has to be rated out. And so that's another thing that they do. Now, Alvarez Guzman can also be applied by us. Maybe the disability it's rare for us, but it has happened, where the strict rating is actually overstating the disability, and the evidence has to be substantial to show that that's the case. It's rare. It's a good leverage argument in certain cases, but good luck getting the doctor to say it, because it's not going to happen very often. The next one is Kite and Vigil. So Kite came down and it basically said that where I was showing you the CVC, where you combine the disabilities, so 210s becomes a 19, so on and so forth. This basically said, well, it's due to the impact on the applicant and his activities of daily living and the ability to do things, it's improper to even use the CVC, the combined values chart. Rather, we should do simple addition. So a 10 plus a 10 becomes a 20 instead of a 19. And as you go down the scale, it gets a 10 and a 10 is still almost the same as adding. But remember what I showed you earlier with a 99 being added, with a 38 and a 49 and a 49, it didn't change anything. Well, the further you get along the scale from 1 to 100, it takes more and more to get the closer to the addition. So it makes a much bigger difference the higher the amount of the disability. And so it seems like it may not be a big deal, but when you factor in, you've got an upper extremity for 20%, and then you've got say you've got a back injury for 20%, and the combined is 34. Well, that's a lot less money than 40%. 40% would be 58,000. A 34 would be 46,000. So there's $12,000 difference. And then as you go further and higher, it gets even more drastic. So it's a way that we're seeing a lot of this. In Vigil it builds on it a little bit further. I don't know where it's going to go exactly, but it is a concern because the way Vigil came is they basically said if the ADLs have no overlapping effect on the or the injuries don't have an overlapping effect on the ADLs, then they can potentially do an addition, or if it amplifies the impact of overlapping ADLs, we can have it. So what that essentially means is, to give you an extreme example, just to make the point, is if I had someone with an eye injury and they were blind in one eye, they can still see, they can still do most of their activities of daily living. But what happens when the other eye starts to go? What happens when the other eye loses, say, 70% of its sight? Well, now this person can't drive, and there's a lot of things that they're going to be unable to do. And in fact, if it gets to a point where the other eye is completely unusable and they're blind, boy, just imagine the activities of daily living impact you're going to have from that. So that's an extreme of how they do it, but it's definitely something we're starting to see a lot of. A lot of cases where I don't even think it applies. The AAs are trying to argue that it should be addition rather than using the CBC, and it's something that we're going to see how it goes. Now, the good thing is even if the injuries are completely independent and they both impact ADLs completely differently, which would be, a perfect example of Vigil and Kite, it doesn't mean the doctor has to use it. The doctor can still use the strict rating, do the CVC, and then, from there, we would be unimpacted by Kite and Vigil. So, and they have to use substantial medical evidence. They have to explain it beautifully. And the thing for us to do it on the defense is to always say, why are you making that opinion? Why? And until you can poke holes in it, or until they support it. Because if they support it, then that's fine too. The next one is Ogilvy. Now in Ogilvy, this used to be a nightmare, all kinds of crazy math, and lawyers are not math people. Lawyers, they go to law school because they don't like math, and that's one of the reasons why rating in the calculators is so wonderful. With Ogilvy, it was tons of math, and it was a very complex analysis. But in reality, the only thing I see left of Ogilvy due to changes in the law is the third method, which is when you get a vocational expert who says the applicant is not amenable to vocational rehabilitation because of the injury, and so they'll say he's unemployable and unable to re-enter the employment market, and therefore they're 100% permanent disability. The thing is what happens is sometimes these doctors, they will, or the vocational experts, they'll use things like the economic conditions, illiteracy. A big one is the speaking English, and they won't factor those into their analysis and take away those factors, because those factors should not count toward whether somebody is employable. And so what we'll do, and it happens all the time, is we'll poke holes and show that they were using factors that they're not allowed to use in order to knock out a lot of jobs that could have otherwise been available. And so it's always an attack on these vocational experts. And anytime I see an expert that gets assigned to a case, a vocational expert assigned by an applicant attorney, I can almost always assume I'm going to get a report that says this person is unemployable and therefore permanently totally disabled 100%. It's just very common. And so then we've got to get our expert and we've got to refute that. Now, Nunez came down, and Nunez is really good because it said what would happen is these vocational experts would just ignore the medical apportionment and say this person is unemployable. And Nunez said, you, as a vocational expert, you can't ignore the apportionment given by the doctors. You have to consider that. So if the doctors, you know, are given 50% apportionment, for example, the vocational expert can't say, oh, well, this person's unemployable because of the disability without considering the fact that half of it was non-industrial. So this is a big case, very big case for us. So now we're going to talk about some apportionment. And apportionment is just that. You apportion something to divide and allocate. So you take a disability and you need to determine what are the causes, and you figure out what's non-industrial and what's industrial. And it can be done by a number of ways. There are two statutes that it applies currently. 4663 is the one that we deal with the most, and that's where we have causation. It determines causation asserted by the doctors is what determines how much apportionment there is. So the doctor can look at all the findings and figure out, you know, how much of the disability was pre-existing, and then make his opinion as to whether it's, you know, 50% work-related, 50% non-industrial, or 10% non-industrial, so on and so forth. But it's based on looking at all the evidence. 4664 is different because that pertains to when there's an actual award already. So if you've got someone with a low back injury and you're trying to evaluate apportionment, and they had a prior low back injury with a finding of 10% whole person impairment. Well, that 10% whole person impairment exists. It will always be found to exist, and so you're going to get apportionment for that 10% under 4664. And it's for this reason that some clients will say, anytime you settle a case, please include a string rating and indicate that the case is settling based on X percentage with this string rating, because then especially if they're staying with that employer, then if there is a later claim, it should be pretty easy to get that 10% knocked off. And it is, importantly, it is defendant's burden. It's our burden to prove for apportionment. So if it's not substantial medical evidence and the doctor says, I attribute 25% to non-industrial causes, but he doesn't support it, and the medical evidence is kind of wishy-washy on it, we're not going to win, because we have to produce substantial medical evidence to show that there's apportionment. Unfortunately, this is a question that comes up a lot. We do not get to apportion to other benefits. So just because 50% of an injury is caused by non-industrial conditions, we still got to pay 100% of the temporary disability caused by the work injury. The same goes for medical treatment. We can't apportion medical treatment, nor can we apportion death benefits. And so it seems to defy common sense, but unfortunately, that's the way it works. And they want to make sure that injured workers are getting their benefits and with as little undue hardship as possible. And so that's what they do, and we have to deal with it. So it's really just focused on apportionment of permanent disability. All right, so special PTD cases. This is an interesting way for disability to be found. Under 4662, there are 4 permanent disabilities conclusively presumed. Conclusively is the key word, to be totally disabling as a matter of law. In other words, these 4 conditions are all 100% PTD, 100% PD. And those include the loss of both eyes, which obviously makes tremendous sense, because if you can't see, how the heck are you gonna, do your activities of daily living? You're gonna need all kinds of assistance in the housing, you're gonna need travel, you name it. The eyes are critical, and the hands it goes the same way with the hands, practically total paralysis, obviously. And then an injury to the brain resulting in mental incapacity. And so then you got to figure out, is that particular case truly a injury to the brain resulting in mental incapacity? Or is there truly practically total paralysis? So those kinds of things will still come up. But the question becomes, is there apportionment when you have these? And it's unsettled. I don't know I don't know how it will be if that specific question is answered, but to me, when it says conclusively presumed, I tend to think that you probably are not going to get permanent apportionment. And so I definitely think it's a problem. So anytime you see these four conditions, it's definitely something to be worried about. And the reality is you're probably going to have 100% in most instances, but again, apportionment just changes everything. If you have a 100% case and you can apportion 50% of it away, you turned it into a $78,000 PD award. So it's big. And I had a case many years ago where an injured worker was a short-time employee in the fields, and she made a claim for chemical exposure to the eyes and was claiming she went blind from it. And so we get the records, and they're just full of diagnoses and treatment for diabetes. And it was clear that the diabetes is what caused this particular blindness. No question, there was no evidence of chemical exposure and things like that. And so we ended up going to a QME, and the QME said, I find that 95% of the injury is non-industrial due to the diabetes, and 5% is work-related. The 5%, in my opinion, was a complete stretch. This had nothing to do with the work, and in fact, there was no evidence of even chemical exposure. So for that opinion to be what it was, I was just like, this is absurd. And so because of this particular statute, I was worried that there would be a finding of 100% permanent disability with no apportionment, even though 95% of it was non-industrial. And so the attorney sends me a letter offering to settle the case, and he gives me his calculations, and he says, obviously the permanent disability is not going to be the driving factor. It's going to be the home modifications, et cetera, for someone blind. And so he makes a demand based on the AOE COE issue, because he may not have even been able to show was work related once I was done with the QME depot. But then he essentially included almost no permanent disability. And the fact is, what he should have done was indicated it was conclusively presumed, 100% PTD, no apportionment, and demanded a life pension, or I should say TTD for life, based on the fact that there was a conclusive presumption of total disability. And he didn't do that, and we ended up getting a very fair settlement, and the case went away. But it was just, to me, stunning that he did not make that argument. All right, so now we're going to talk about some of the things that we look for when it comes to finding apportionment. One is prior industrial injuries, including any awards, and that's probably as obvious as it gets. As I said earlier, under 4664, the prior award will be presumed to still, the disability will be presumed still exist. Another one is prior non-industrial injuries. And this is such a big one because it not only goes toward apportionment, but it goes toward causation. And if any of you have heard me before, whenever I've got priors, I like to use a deposition as a lie detector test to see how they testify, and we set it up in a certain way so that we're going to get an honest answer and they don't know that we know. And then we wait until we get a deposition before we even get the records on these cases, whether it be work injuries, et cetera, because we don't want a copy of those records going to the applicant attorney, who then reviews them and then prepares the applicant so that the applicant knows what we know. And then when I take the deposition, it's not a good lie detector test because he already knows we know it, and he'll tailor his answers to what the evidence is. Whereas if we didn't subpoena it and the AA doesn't have a copy, we know all the questions to ask, regardless of having seen the records. Then we go get the records and we see what's in them, and if they are impeaching, then the applicant's in a world of hurt. So it's a great way for us to build apportionment, but also to assess credibility and AOE COE. Next is subsequent injury. Sometimes someone has a subsequent injury and you need to know about that. Maybe you run an ISO at some point and the ISO turns up that there was a subsequent injury that could be at play. And I have had multiple cases where there are subsequent injuries, and I get the records, and they're alleging one thing in the new case, they're alleging one thing in ours, and they're inconsistent with each other. You know, I had one, for example, where they said, oh, I had a fall and I injured everything on the left side of my body. And then they had a subsequent fall, and then they injured everything on the right side of their body with a different employer. And so they separated them out that way. And the reality was they both were illegitimate claims, as was shown, but I've seen various other claims like that as well. We look at prior symptoms or complaints. You know, that's harder because we need more than just them saying, well, I did have some back pain here and there over the years. We're gonna want treatment records. The doctor's gonna say, yeah, you know, maybe I'll give 10% due to the applicant's reported symptoms and complaints prior to the injury, but I can't give more than that because I don't have any medical records that show the extent of the complaints, or I don't have MRIs or anything like that. And some of them will just say I can't do it because I don't have any medical records, and it's just saying that I had some pain on every now and then is insufficient. So, but nonetheless, it's very important, and especially if we get records. If we get records, we can get apportionment, and we can, again, it goes toward AOE, CEU, and credibility as well. So the next factor is risk factors, and that's even if they're not symptomatic. Risk factors can play an obvious part in a disability, just as genetic factors, because some genetic factors will cause a disability regardless of the work, and the work can really just be a stage for it, or the work can just be a partial cause of it. You know, for example, cancer is a genetic. There's a lot of genetic factors when it comes to cancer. For example, and I may have said this to some of you before, my family has a BRCA gene that runs down, and it gets all the women, and I mean it gets all the women. They all get, in my family, they all get ovarian and breast cancer, either some young and some older, but it's brutal to my family. And so if someone were to have a genetic factor, a gene that can give them a certain type of cancer, and then they get that cancer and they're working, you're going to want to know that. So we always look at genetic factors as well. Obesity is a big one. Obesity causes so many medical issues. It's not just you know, especially like cardiovascular and diabetes and, you know, all those kinds of things which become part of claims. But it causes a lot of wear and tear on the knees and on the joints, etc. So it's a big indicator of potential disability. And you know, if you've got a knee injury, for example, on a 60-year-old who's heavy, and I'll stick age in there for now, who's heavy, well, there's a good chance they're going to have abnormal MRIs. There's a good chance that they have a lot of degeneration, and they're potentially already and would have been a knee surgery replacement candidate. And so we would expect apportionment on these types of things. Next is smoking, drinking, drug use. You can imagine if you've got a respiratory injury and the person's a smoker, how that can impact the opinions of a doctor. I've even seen it where the doctor puts it all on smoking in internals. So that's drinking, drugs, all that's important because it just beats up the body. Comorbidities such as diabetes, heart disease, I touched on that already, but diabetes is a big one. That one causes a lot of problems. It's oftentimes completely non-industrial that unfortunately at times, even when it should be completely non-industrial, doctors will bring it in, say 10%, and then as I mentioned earlier, when you get no apportionment for treatment, you're stuck with all the diabetes treatment, even though it was only 10% worsened. The next thing is we'll look at all the diagnostics. Very often we get an MRI, for example, or x-rays, and we see a lot of injury that appears to be pre-existing. That's not something you would get just from a specific, for example. And so we'll want to see all of those and make sure the doctor sees it so that they can give us apportionment. Maybe it'll only be 10 or 15%, Maybe it'll be more, maybe it'll be none, but typically you're going to get it if there's old findings in there. And it also gives you, it goes to AOE, COE. Are these findings that must have existed on the day of the injury from the injury, or could they have been pre-existing? And do you know when they first came about? And if the doctor can't say with certainty and has to rely on the credibility of the applicant and the history given by the applicant, well, then you got an argument. Another thing is date of injury. You know, so say you got a specific trauma and they're alleging it's big injury, and you look at it and you're like, well, you know, there's degenerative findings and arthritis and some of this stuff looks pre-existing. Maybe it's a CT too. Maybe there was a CT. Look at the kind of work this guy did. It was very, very hard work, and it would have caused problems with these body parts. And so then you get the doctor to say, yeah, I would agree that there's a CT and a specific at play, and I give these percentages to each, and now you got 2 awards, which is worth way less than a single large award. So that's another way to do it. Then we look at hobbies, sports, and other ADLs. I want to know everything that this person's done. What's their life been like? If they've had a really hard life of work, or they've had a really, they've done a lot of hard work around their house, or they you know, they got a shoulder injury, but they played baseball for 20 years, or they got a shoulder injury and they shoot shotguns a lot, you know, things like that. I want to know that, because that could really have an impact on apportionment. Non-industrial psych injuries or issues are also important, because that can go towards someone's essentially they feel like you know, I'm doomed, I can't get better, and so they exaggerate their injuries, and it can have an impact. So what you'll want to do is show that the psych issues are really what's at play here, and they're non-industrial. So apportionment requires discovery. One of the things we like to use is medical canvases, because we can figure out where the applicant's treated. Diann said earlier today how important the pharmacy records are, and I didn't used to love pharmacy records many years ago, and then I started seeing how helpful they are. And she's 100% right. They're amazing, because they have information on medications, who the doctors are that have treated the applicant. If they don't disclose that stuff to you, then you can get it in this medical canvas, and particularly pharmacy records, if you don't have a lot of leads. The next one is,
James,
yes.
I just want to talk a little bit more about what medical canvassing can do.
Do it. Yeah.
It's really important. So when you get a good medical canvas, you know, you can look and get information on pre-accident treatments, right? So you know what's happening, what prior injuries there were. You can determine whether or not the injuries were related to work, or if there was some pre-existing condition that maybe the injured worker hasn't told you about. Perhaps the other thing it can do is it could tell you whether or not you have a truthful injured worker, because maybe they are disclosing things to you, and you're able to use that medical canvas to say, oh yeah, what they're telling me is correct. However, you can also find information in these records that maybe the injured worker didn't share for you. Maybe you can find out if there's any drug-seeking pattern, because we're seeing this type of information. Whether or not, like I said, the exposure of the claim, if it's really work-related, or if they injured themselves, like you said, or maybe on a baseball diamond or something along those lines. But there are a lot of things that people should be looking at with medical canvassing. It's more than just pharmacy records, because there's a lot of ways that you can tell whether or not your injured worker is either being truthful or not. And I think that's really valuable, because we need to know if we could trust this person.
Absolutely. I'm a huge fan of medical canvases. They've won cases, literally won cases for us. This is a list here of various ways that we use it. Surveillance is a big one as well, but we use all of these are tools so that we can get apportionment. And I'm going to move a little bit faster here. This if you ever need it, you can compel responses about prior injuries previous permanent disabilities or impairments. And it's something that you can get a court order to compel if the other side does not provide you the answers to that question. All right, so now I'm going to turn it over to you, Diann.
All right, thanks, James. So we do want to talk a little bit about discovery tools and how we use them and how the attorneys use them. So I'm going to go over them, and then James, I'm going to ask you how you use them, I think. So there are some very valuable tools that your document retrieval company should be providing to you. For example, OCR records. James, do you use that very often, the OCR records?
I don't, but it's something that is at the top of my mind to start looking into.
Yeah, because you could put in a body part, an injury, a word, and all those records, every page is going to come up that's on there. And it's a great way to be able to eliminate pages. That's a great thing to do. Also, your document retrieval company should provide you with an EDEX. An EDEX, one EDEX per claim, and what that tells you is whether or not they've ever had a workers' comp injury before. If they tell you no and you've got an EDEX that says yes, well, we already know what type of character we're working with. We also, document retrieval companies will go in and look at the records to find out whether or not there are more records that are available to you that you may not be aware of. And we call it MP discovery. Other companies might call it something else, but I don't think many companies provide that. And it is an amazing service because all of a sudden you got a list of chiropractors or other doctors that may be able to provide really valuable information that you can then subpoena the records for. Of course, a summary and injury summary of records is really important, especially if it's summary, because our nurses could go through, summarize everything, and only give the pieces that are actually relevant to the case. So you're not sending more paper than you really need. And then an X-ray breakdown. This is fantastic. I certainly hope, James, you utilize this because an X-ray breakdown will tell you, you may say, I want to have all the X-rays on the lower spine. But if you get a breakdown, it's going to tell you every X-ray they ever had. And that's really important because let's say they're claiming a knee injury and it's the right knee and you go after the right knee. Well, if we then tell you that there are 15 X-rays on the back and the left knee, now you can say, well, if their left knee was bad, they're probably babying it with the right knee and now the right knee is having a problem. So this is a pre-existing condition. Maybe you don't own 100% of it, right?
Sure.
In addition to that, if you need to get your Social Security, disability, and Medicare verifications done, your document retrieval company should be able to do that. And then the free services. Now, earlier we looked at the calculators that we have that is so great, but we have other ones like past and present day calculators, which is great. You put in a date, it'll tell you how many days you put down if you want business days or actual days, and then it'll tell you 90 days out, that type of thing. And that way you're not looking at a wheel. For those of us who have eyes that are older than 25, it's kind of nice not to have to look at a wheel and do the counting, right? We got earning calculators, interest on awards, so that you can make sure you're sending out the right amount. And then this is a really good one, to have a certain type of databases that are available to you. So we have doctor and hospital databases available to you, and also licensing boards. And what was really cool one time, this is probably back in, I'm gonna say the early 2000s, we had a doctor and the examiner couldn't find the doctor. She couldn't find a doctor at all. We went onto the tool cases, but his license was expired and it wasn't renewed. And so that, was a lot of information that she was able to utilize. So you never know what you're gonna see. Next slide. Need to advance that, please.
Next slide.
Mm-hmm. All right. So subpoenas, obviously, we subpoena records. And James, you did pass one slide up. You can go back for a second here. So subpoenas obviously are really important, and it's really from an attorney's perspective. James, how is it you guys utilize subpoenas? Because obviously we're going to go out, we're going to get the records that you asked for, but what is it that you guys use them for?
Oh, I mean, we use them for everything. We use them to attack AOE, COE, to get apportionment, to attack the amount of disability in general, show criminal records can show credibility issues, employment records can show other injuries. It's subpoena records is how we build our case. The only other evidence really that I mean, probably should think of it more, but is like surveillance and depositions. And outside of that, it's subpoenaed records.
Yeah, absolutely. And, I remember a case that was on a civil side, and, we just don't close down orders. We don't. We follow through. A lot of companies will close it down to make their turnaround times look better. But we actually followed this one case, I think it was about 3 years, and we finally got the records just when the actual trial was happening. And, the client was so excited and happy because we followed those records and we got a certificate of no record. And once we find out there was a certificate of no record, we went to them and said, why is there a certificate of no records? Well, the doctor left the practice. Okay, so we go over and we search, and then we're just keep following and leapfrogging until we actually get the records. It's a lot of time, it's a lot of work. Not every company is going to do it, but you want a company that will do that for you, because that could be the evidence you need to shut down that claim. Next slide. All right, so this is also really important. So interstate subpoenas, so the UIDDA, which is the Uniform Interstate Deposition and Discovery Act. And this was enacted somewhere around 2007. And this is when the states realized, you know what, I need records from one state and the other state needs to get records, but there was no uniform way of doing it. Every state required its own. California subpoena had no teeth, and Florida, for example. So what was to happen? So they put together this act in order to help the different states work with one another to get this to happen. And so now there's 47 states that are participating in it, and there are only 3 that aren't doing that. And so that's Missouri, New Hampshire, and Texas. And does that mean we can't get the records from these places? No, it just means we have to do something different. And in Massachusetts, for example, even though they have enacted it, they still require some different information. Now, it's a lot of work. Most places won't do it. Most law firms can't do it. So they have us do this work for them. So know that if you need records from another state, it is doable, and it's something that we can do for you. Next slide. International records. Now, people travel internationally for work all the time, and sometimes they're there for a while and they get injured on the job. So how do you get these records? Well, we have gotten records from 6 continents, and well, we say 33 countries, but that was at last count about 5 years ago. So I'm certain that the number is actually higher than that. And it's just a matter of us figuring out what needs to happen. For example, in Israel, we have 12 rabbis that will make the final decision whether or not the records can leave the country. And so, we are willing to do the research and find out what needs to be done to make it happen. In Mexico, for example, the records are supposedly very difficult to get because you're not supposed to release that information, but the facilities don't always do it that way. We had a case one time, our office is a virtual United Nations, okay? We got people from every background in the world. And so we would call and we'd say, hey, we know that there's records. The injured worker told us that there's records. We need to get these records. It took us about, I don't think it was 7, 8 different employees that called, and it just took the right dialect. Once we got the right dialect, they were happy to retrieve those records for us and release them. So it's a matter of finding a company that's going to be really tenacious and really try to get these records for you, and not just say, well, they're international, we can't get them. So it can be done. Next. Emergency services. Now this is interesting because usually when somebody wants records from emergency services, they provide the standard information, the injured worker's name, their social security number, the date of the accident, but they need to get these emergency service records. Well, they are not filed that way. They are filed by date and time and the address of where they rolled up on. So you need to make sure that you provide that information to your document retrieval company so they can do that. And for those of you who heard me speak before, I talk about a case where it was social media, where there was a gentleman that was claimed a broken finger, and we found out through social media that he was an MMA fighter and that he had fight the night before he claimed his injury. And of course, his injury was unwitnessed. So we found out who did the event, and we found out who they hired. So the attorney, got that information. We subpoenaed the records, and the police on file said, no, there were no altercations. They were not involved in any altercations. But we do know that he was involved in fighting because he was on the agenda for the evening. So then we went to the ambulance company and found out that he was treated, and sure as day, it said that he broke his finger. So we were able to get that information and shut that claim down. And it was really great for the examiner. They were able to say, hey, you want to shut this down, or do you want us to continue and file a fraud case against you? I mean, that's lovely, right? It's so great when records can be so clear cut for you. Next. So an ISO report, this is the largest database out there. Now, this is mostly for property casualty losses, but if you have access to it, it is really great to be able to do. It has really robust information as far as claims is concerned, and it can provide you with so much more information. For example, whether or not there's multiple policies, if they've ever been involved with any type of SIU actions before, if they're using the same Social Security numbers as other people on their claims, etc. So this is a really great document. It provides a lot, and not everybody can get it, but if you're an insurance company, you can. So utilize it if you can, because it'll provide James and his team lots of information that they can utilize. So send it to them as soon as you get it.
Yeah, we actually want to see this in every single case, because it really is our best tool, because it's the only database that includes everything. It includes all different types of injuries, whether it be work-related or a non-industrial car accident, etc. It's all in there, and it's fantastic. We need it, and we can't get it. We have to get it from the TPA, because they're the ones that have the access to this database.
Yeah. And then records from Uncle Sam. And I see we're coming up on time here, but I just want to point a few things out, because some people are like, I'm not very successful getting these records from Uncle Sam. Well, first of all, Uncle Sam could take about a year. But you'll notice here if you look at the first three, they're military records. The one in the middle of those three says request for information needed to locate the records. And that's usually why they're not successful. They are sending requests for the military service records, but they're forgetting to ask to locate. And our military bases have shut down. We do not have the same number of military bases that we've had in the past. So where are those records? There's not one repository in the nation. So we have to actually go and look for those records, so the government does. And once they look for them, then you have that permission to actually copy them. And the same with Social Security, you'll see that you have to have a consent release for that. So you not only do you have to sign the release that to get the records, but you have to have the consent to do that. So just be aware, sometimes Uncle Sam can be a little bit difficult, and you want to make sure that you get all of the authorizations that you need to have that. And then again, I want to remind you that if you need Social Security or a Medicare verifications, a good document retrieval company like ours can do that for you.
Yeah, Social Security earnings statements are a big one for us. We don't come upon too many military people, it seems, but Social Security is really important, because it can show other employers that you were unable to find earnings, and it all goes toward all the issues. I mean, AOE, COE, wage compensation rates, apportionment, you name it. It's a helpful tool, but they just seem to always take so long to get. Do you have any tricks on how we can get them sooner?
Order them soon as
Yeah,
file start.
yeah. As soon as you have any idea, just get them, right?
Actually,
Yeah.
we do have a way to do them a little faster than normal, and we can do them faster than like the MSA companies. So a lot of those companies utilize our services now because we can do it faster.
Gotcha. All right, we already talked about social media and medical canvases. So this is the last slide, and essentially it just gives you the main summary of how we get apportionment and defend the cases. And so you can go ahead and peruse that. I think we're done with time. Is that correct, Diann?
We are at time. And Mandy, do we have any questions? I don't think we have any questions.
No questions. There was
Awesome.
one though. from Keisha said, thank you, interesting. Had an employee injured in Japan. Very difficult to obtain those medical records.
Oh, interesting. Yeah. Well, thank you, Keisha, for that input. Also, somebody was asking about the handouts. So we just want to make sure that you realize there are handouts. So if you'd like to download them, you should be doing it right now because we're going to be signing off in a second. So we want to thank all of you guys for joining us. James, thank you so much for being the last speaker for our 12 CEUs of Christmas. I appreciate doing this with you. You're always fun to work with. And Mandy, thanks so much for co-hosting this. And until next year, we wish you all a very, very happy holiday. Bye-bye now.
Thanks, Diann, and it's been a pleasure working with you this year. And thank you to all the attendees. And I know a lot of you have been to many of the sessions that we've done. And I just want to say I really appreciate it and happy holidays to everybody.
Yes, absolutely. Actually, I want to say Yvonne. I think Yvonne has attended almost every single one of the 12 CEUs. Yvonne,
Nice.
can you put that in the chat box real quick if you actually went to all 12? Because I think I've seen your name every single time, and that is pretty amazing. We are happy to have these programming for you guys, and we will continue doing it in 2025. This year we did 42 webinars, and we did about 60 hours of in-person training. So when
Amazing.
you need education, Macro Pro is here for you. All right, well, I don't see that. Oh, let's see here. Let's see. Patricia says she loves it and she's attended all of them. Well, excellent.
Wow.
Excellent, Patricia. Okay, and Yvonne did reply back and she says, yes, she's been to all of them and thank you. So, all right, well, we're gonna go ahead and close this off now. Thank you all. Again, you can watch this on the Macro Pro YouTube channel starting tomorrow. Bye-bye now.
Bye.
Bye.
Bye.